Rules Committee will come to order, and thank you very much for joining us today. Before we go too far, I want to acknowledge the storm that occurred this last weekend. And Judge, you had a birthday last week, but you also had a terrible storm that has caused extensive damage and a good number of people, notwithstanding our territories, but now it includes Florida and points north. And I wanted to go to you and have you be able to express on behalf of the committee our not only respect for the first responders, but also to the men and women who are there. Gentleman's recognized.
Well, thank you very much, Mr. Chairman, and you're wise to point out the extraordinary work that the people on the ground have done. Let me thank you and all of our colleagues that have expressed concern for those of us in the region. There were surprises along the way. Jacksonville, Florida, when we left here last week, no one thought they would have floods. Charleston, South Carolina, no one thought that they would have floods. And along the way, the biggest damage in the state of Florida was done in the Keys. However, we have minor damage and tremendous power outage. And I don't know how you calculate all the loss of stuff that people have in their freezers, but that's better than in the final analysis, the loss of life. One thing I can honestly say without any hesitation whatsoever is the governor's office, the two senators, and the Florida delegation, as well as the local authorities. I've been in contact with them, and I can't say enough good about FEMA and how they have handled matters, Mr. Chairman, as well as the related agencies. But we did learn a couple of things along the way, and that is that there needs to be better coordination of the agencies dealing with recovery. However, I'm deeply appreciative of your concerns as well as committee members and others that have expressed their concerns. Thank you so very much, Mr. Chairman.
Yes, sir. And just so the gentleman is aware, you would expect us to say that if there is something that we have missed in the package that we did last week that becomes apparent, this committee would join with you, or at least I would join with you in anything that you felt like we needed to pursue, where we could work together, where we would be able to enunciate the necessary legislation or fixes. And I want to thank you for not only your time, but the anguish that comes with that service. Yes, sir. Today, the committee will consider H.R. 3697, the Criminal Alien Gang Member Removal Act of 2017. U.S. Immigrations and Customs Enforcement, or ICE, has found that membership of violent transnational gangs is comprised largely of foreign-born nationals. In 2016, over 2,000 criminal aliens were removed by ICE and were classified as suspected or confirmed gang members. The largest and most brutal of these gangs is known as MS-13. It's a transnational gang that is notoriously violent and comprised of members mostly from Central America. It is estimated that MS-13 has over 10,000 members in the United States of America, and that they are wreaking havoc in our communities across the nation, from Long Island to Boston to the suburbs of Virginia. This violent gang is using machetes to kill individuals and to intimidate entire communities. In order to protect America from violent gangs, the Criminal Alien Gang Member Removal Act ensures that alien gang members are kept off our streets by barring them from coming to the United States and detaining and removing them if they are here and found. It does not really get any simpler than this. If you're making our cities and our suburbs safer, you should support this bill. If you're for removing gang members from this country before they have an opportunity to wield their machetes and their violence on innocent victims, then you should certainly consider this bill. MS-13 is no different than the scourges of criminal organizations like the Mafia or other gangs that we've seen attack our communities in the past. We have never failed to come together to halt the spread of organized criminal organizations, and to adjust our tactics to the latest threat and provide law enforcement with the tools necessary to not only counter, identify, but to defeat them. In this case, deport them. This legislation is no exception and will provide law enforcement with the tools to halt the exploitation, murder, prostitution, drug smuggling, and violence that is occurring, unfortunately, every day in cities across our nation, mostly in the suburbs, by these transnational gangs. This legislation continues to provide due process while ensuring criminal alien gang members can be removed. I'd like to welcome the gentleman, my dear friend, Congressman Mike Johnson, as well as the gentlewoman from California, my friend, Congresswoman Zoe Lofgren. Without objection, anything you have in writing will be entered the record. However, before we get to you, I want to yield to the gentleman, the ranking member from Massachusetts. Gentleman is recognized.
Well, thank you, Mr. Chairman. And I'm not going to get into the substance of the bill. I'll let Ms. Lofgren address that. I just, we're the Rules Committee. I just want to address the process. I mean, we have legislation before us that has had no hearings, has had no markup. We have been inundated with letters from civil rights groups, from legal scholars, from religious organizations, human rights organizations, on and on and on, pointing out that the way this bill is drafted, there are lots of problems with it. And then I see this letter from Chairman Goodlatte asking for a closed rule. So no hearings, no markup, and a closed rule. I mean, if people want to know whether or not regular order is dead, I mean, this is an indication that it is dead. It doesn't exist anymore. This process is appalling, and I think we have an obligation on this side to point that out. I mean, again, you can bring whatever you want to the floor. You're in charge. It'd be nice if the committees of jurisdiction would have an opportunity to deliberate and work their will. Obviously, in this case, that's being denied. But at least open it up and let members who, again, have just seen this legislation, because this is carefully guarded secret, I don't know why, to be able to offer amendments. And you're asking for a closed rule. So, I don't, we can get into the substance of this, but the process stinks. And I want you to know that on our side, we deeply resent, again, having to consider yet another bill under this kind of process. So with that, I yield back my time.
Yes, sir. Thank you very much. To defend this topic today is a gentleman from Louisiana, member of the Judiciary Committee, and very able member also, Ms. Lofgren. The gentleman from Louisiana is recognized.
Thank you, Mr. Chairman and committee members. I'm pleased to be here today to testify about H.R. 3697, the Criminal Alien Gang Member Removal Act. It was introduced by our colleagues Barbara Comstock, Raul Labrador, Peter King, and our chairman Bob Goodlatte, Judiciary Committee. The United States is facing an ever-growing threat from transnational criminal gangs. It's beyond dispute. In communities across our nation, these gangs use horrific violence and the threat of violence to create a climate of fear that allows them to operate with near impunity. They regularly target local business owners and law enforcement officials, with passersby unlucky enough to be in the wrong place at the wrong time, also often paying a price. As U.S. Immigration and Customs Enforcement has found, these gangs, quote, have grown to become a serious threat in American communities across the nation, not only in cities, but increasingly in suburban and even rural areas. And entire neighborhoods and sometimes whole communities are held hostage by and subjected to their violence, unquote. Perhaps no transnational gang better exemplifies the use of murder and mayhem than Mara Salvatrucha 13, also known as MS-13, which was formed by Salvadorans who entered the U.S. during the Salvadoran Civil War in the 1980s. MS-13 is notorious, and it's made us all too familiar with the phenomenon new to our shores of persons being hacked to death with machetes. MS-13 has over 10,000 members operating within the U.S., and ICE believes that MS-13 is, quote, one of the most violent and rapidly growing transnational street gangs, unquote. At every level, our law enforcement officials are working to curb this cancer growing in our neighborhoods with large-scale enforcement actions, such as Operation New Dawn, which over a 6-week period netted almost 1,100 arrests of gang members. While criminal prosecutions remain a crucial tool in the fight against gang violence, we are vulnerable to alien gang members exploiting dangerous loopholes in current immigration law. Currently, an alien may not be deported even if that alien is known to be a member of a criminal gang or participating in gang activities. ICE is forced to wait for the gang member to first be convicted of a deportable offense. All of this while ICE is forced to watch and wait as the alien continues to flagrantly participate in dangerous gang activities. H.R. 3697 will, for the first time, permit alien gang members to be placed into removal proceedings on the grounds of being criminal gang members. The bill sets out clear parameters for what crimes are considered gang-related and relies on long-standing federal criminal law definitions to determine what a gang or group consists of. In addition, it provides that the Secretary of Homeland Security, using procedures already used by the Secretary of State to designate foreign terrorist organizations, may designate a gang as a, quote, criminal gang. And this would be done transparently through notification to Congress and publication in the Federal Register, and with meaningful judicial review. The ultimate decision as to whether to place an alien in removal proceedings rests with the Department of Homeland Security. And once an alien is charged, the charge must be proven by evidence on the record in immigration court. Specifically, I've heard concerns that ICE will use these provisions to charge any alien they encounter. We believe those concerns are misplaced. ICE maintains the burden of proof when charging an alien with a deportable offense, and while the alien has the burden of proof when they are inadmissible, a denial of gang membership would be sufficient to shift the burden back to the government. The government must convince an immigration judge of its case. And of course, an alien ordered removed as a gang member has every right to appeal that order to the Board of Immigration Appeals and ultimately to the federal court. At the end of the day, this bill is about providing law enforcement with the necessary tools to combat gang activity in virtually every community in this country. We must take action now or watch homicide and violent crime rates continue to soar as federal immigration remains unable to take action to remove alien criminal gang members from this country. I just wanted to address very briefly Mr. McGovern's concerns about the lack of process, as he said, and point out that this is part of larger legislation that passed the full House in 2005 and passed Judiciary Committee hearings in the 113th, 114th, and 115th Congress as part of larger legislation. So it's not an unheard of measure and has been widely discussed. And I look forward to answering the committee's questions. Thank you.
Thank you very much. Ms. Loughran, welcome to the committee. We're delighted to share. Gentleman is recognized.
Thank you, Mr. Chairman, and thanks for the opportunity to testify today on this bill. Gang members and serious criminals should not be granted admission to the United States. That's not a controversial position, and I think almost every member of Congress, Democrat or Republican, would agree. It's our highest priority to protect the safety of the American people, and that's a duty I think we all take seriously. The title of this bill is, as has been mentioned by my colleague, the Criminal Alien Gang Member Removal Act. Now, as in the past, the name of a bill is not always reflected in the actual proposed language of the statute, and that's quite true in this case. If the bill had stayed true to its title and really focused on dangerous gang members, that would be one thing. But this bill goes much, much further than that. First, Section 2A of the bill defines criminal gang as, and I quote, an ongoing club, group, organization, or association of 5 or more persons that has one of its primary purposes, the commission of one or more of a wide range of offenses. Now, that may seem reasonable until you look at the offenses listed. And these offenses sweep in many people that I think no reasonable person would think of as a gang member. For example, one of the offenses relates to the harboring and transportation of undocumented immigrants. Now, this statute is not about alien smuggling or trafficking. It covers people who give shelter to, transport, or provide other kinds of aid to undocumented immigrants. That means, under this bill, a religious organization that aids undocumented immigrants would be a criminal gang. I think that's why we have so many letters from religious organizations expressing grave concern about this bill. Now, any clergy or congregationist who assist in these efforts would be deportable. And we're not talking about people who are here in an undocumented status or have a temporary visa. We're talking about people who are legal permanent residents of the United States, who are usually thought of as U.S. persons who have all the constitutional rights associated with American citizens. We treat them, for example, when we look at the surveillance statutes, we treat U.S. persons, including legal permanent residents, in the same status as American citizens. Now, the concern about this isn't just theoretical. During the 1980s, members of the faith community were repeatedly criminally prosecuted for providing transportation to undocumented immigrants. In one case, the FBI even infiltrated a Bible study group to learn about the group's plan to support undocumented immigrants. Under this bill, DHS would be authorized to go after all such groups as criminal gangs. In one fell swoop, it turns nuns into gang members. The bill also refers to any felony drug offense, which would include repeated possession and use of marijuana. Now, under this bill, and I would say as someone who comes from California, where the voters of California decided to approve first marijuana for medical purposes and later for all purposes, under this bill, any group that legally gets together under state law to use marijuana would be a criminal gang. That could include even people, I understand that people who have epilepsy can gain relief from epileptic seizures through the use of marijuana. So if you had a group of epilepsy patients or cancer victims who use marijuana to deal with nausea, if you had cancer patients or epilepsy patients getting together to use marijuana consistent with state law, they would be a gang. It could also include high school kids that regularly smoke marijuana behind the bleachers after school. Now, you may or may not agree that this is a great thing to do, but I think most of us would agree that's not MS-13. That's not what the title of this bill says we're dealing with. Second, the bill authorizes DHS to deny admission or deport any immigrant, including one who has no criminal history or gang affiliation whatsoever, so long as DHS merely believes the person is associated with such a group. I understand the chairman may be offering an amendment to address that one aspect of this bill, but even if that amendment is adopted, it doesn't really fix what's broken in the bill. Section 2B and 2C of the bill expressly authorize DHS officers and immigration judges to deport any immigrant, including lawful permanent residents, on nothing more than a reason to believe that the individual has been a member of a gang, including the Gang of Nuns, as described earlier, or has participated in the activities of a gang, including the cancer marijuana group. There's no need for a conviction. There's no need for an arrest, just a belief. The person doesn't even need to be a member, really, of the suspected group. All DHS needs is a belief that the individual assisted any group of 5 or more people that DHS believes has committed one of these long list of offenses. The belief could be as minimal as the color of a person's shirt, the neighborhood they live in, the individuals in their family. It's not much of a standard. It's not only unreasonable, I think it's probably unconstitutional. Now, Chairman Goodlatte, if he does offer his amendment, would, I guess, recognize the fact that the reason to believe standard is really indefensible, but as I said, it really doesn't fix the problem. The amendment would eliminate the extremely low reason to believe standard with respect to deportation, but which applies to permanent residents and other immigrants. But, as introduced, the bill actually authorizes DHS to strip permanent residents of their status and thus separate them from homes, families, livelihoods on nothing but the suspicion of an association with one of the groups described. And I would note further in the bill, there is a prohibition on bail. So if I have a belief that you, Mr. Chairman, are affiliated with a group that I consider a gang and arrest you on that belief, you're going to be in jail without the possibility of release for a long time, because as we know, our immigration courts are severely backlogged. In that time, you lose your job, you lose your home because you can't pay the mortgage. Who knows what happens to your family? Even with the proposed amendment, DHS would be authorized to deport lawful permanent residents who assist groups that help undocumented immigrants, as I say, or belong to the epilepsy or cancer groups that smoke marijuana. Even with the amendment, it could deny admission to anyone who is merely suspected of such a thing. Now, I met this afternoon with actual police officers, members of PORAC, which is the largest law enforcement group in California made up of line officers. And they asked me to do what I could to defeat this bill, which they said was an unwise bill. They told me, and they were there to talk to me, about the gang problem, because we have gangs in California, and it's a real problem, and it's something that happens in my district and other districts around the country. But bills like this, which could turn nuns and cancer victims into targets, are only going to get in the way of real police efforts to go after gangs. Now, if we want to keep America safe and admit immigrants who do not have a felony record, I would suggest that we consider the Bipartisan DREAM Act. That bill would provide legal residence for 800,000 young people who were raised in America, who consider this to be their home, represent the best of our country, have passed all the background checks. We should do that instead of debating whether we should deport nuns. We should focus on what really makes this country great. I hope that we will not report this bill, and I urge all of you to oppose it. And I do have a list, which I would ask unanimous consent to put in the record, of statements from the Advocates for Catholic Social Justice, the Bethany Christian Services, Church World Services, Lutheran Immigration Services, the Methodists, the Lutherans, Sisters of Mercy, as well as Human Rights First, the National Hispanic Leadership Agenda, the American Immigration Lawyers Association, the Immigrant Legal Resource Center, the National Immigrant Justice Center, the Project for Immigration from the Lawyers Guild, National Immigration Law Center, the American Civil Liberties Union, County of Santa Cruz Probation Department, as well as a letter just received from the U.S. Catholic Conference of Bishops in opposition to the bill.
Thank you very much. Mr. Johnson, on page 5 of the bill, designation of criminal gang. Line 16, number 1, in general, the Secretary of Homeland Security, in consultation with the Attorney General, may designate a group, club, or organization with an association as a criminal gang. Do you believe someone's going to go pick on a church?
No, sir, I don't, Mr. Chairman, and it's clear, and it's important for us to point out, this bill does not target, quote, nuns and cancer victims, as has been said, and anyone who gives it an objective and fair reading will understand that. It is intended to go after known gang members.
That's the way I read it, Mr. Johnson.
There is zero threat that a
And
church will be caught up in
The bill,
this.
which is small enough to read, repeatedly speaks about this, including the name of the bill, and it's specifically related to gang members and people who are in this country and are committing crimes, and they include, among others, harboring of people. And harboring of people, many times, as I understand from law enforcement, is done where they bring people in this country and beat them mercifully and hold them against their will. And to align that with a church that's bringing people in under another designation is a stretch to me. Can you please talk to me about the burden of proof in the immigration court and appellate rights that may be also addressed within what we intend to authorize today?
Yes, Mr. Chairman, that's a very important point to make. All of the safeguards that exist in this very important piece of legislation. First, ICE has the discretion of whether or not to bring these charges, obviously. That's the first step in the process. After that, the judge has the discretion to make the court's determinations, as is always the case in situations like this. And in addition, you've got a third area. It's all the due process guarantees that exist. You have the burdens of proof. You have the rights to appeal and review. The burden of proof shifts immediately back to the government, as I mentioned in the opening statement, if the charge is denied. And so all of those safeguards are in place. The legislation is carefully drafted to ensure that, so that no one who is beyond the scope of what's intended with the bill get caught up in it. This is to go after dangerous gang members who are causing havoc in our streets, and I think it's tightly written enough to accomplish that end.
Mr. Chairman, if I may on that point,
Yes, excuse me just one moment. Sir, do you believe that there's language that's taken from other states that successfully are trying to do the same thing?
I believe so. The language here has been put together after careful study and consideration. And by the way, I think it's worthy of note that the definition in Section 2 on page 2 that Ms. Lofgren was referencing comes straight out of 18 U.S.C. Section 521, which has been a part of our law since 1994. That's the criminal code definition for sentencing enhancement. And so there's really nothing new here under the sun. It's very important to point out this is language that we're familiar with in the criminal code, and we are employing it here for very good reason.
Ms. Lofgren?
I think this bill can be read in a very confusing way because there are really two sections. The second section creates a very elaborate procedure for the Secretary of Homeland Security to designate the groups. It includes...
And to advise the Congress therein.
To advise the Congress, to put in the federal record, da-da-da-da-da-da. However, the first section basically leaves it up to the line officers to decide. And so there are two provisions, and the second is confusing because it does not diminish the capacity of a line officer to utilize the provisions on page 2, starting on line 6, and proceeding through page 3, as I described in my opening testimony. I would note also that on page 11, as you see on line 7, once the procedure has been engaged in, even on the second matter of proceeding, you have no capacity to actually challenge that designation if you're an immigration court, which I think is unwise, because if you were a nun and didn't notice that it was in the Federal Register, you should have an opportunity to be heard. But that's just an aside, assuming that the Department of Homeland Security would not designate the Catholic Church, and I think I do assume that. That doesn't mean that the thousands of officers that we have roaming the interior of the United States might not decide that those who are 5 or more, who are essentially harboring, and there's a whole law of harboring, and it's primarily religious people who are doing that, aren't running afoul of this statute, and in fact, they would be.
Do you believe that a church or these nuns would be, or the effort of what this legislation's about?
I don't know. I don't know whether...
Do you believe it?
I have no idea what the...
How about if I told you it's about MS-13 gangs?
If it were about MS-13 gangs instead of the unintended consequences, we would be having a very different conversation,
How
Mr.
would you
Chairman.
define a gang then? Let's assume criminal, alien, people that if you're in law enforcement, you can see activity, criminal activity, but you have to somewhat describe it in law to identify these groups of people.
I will just say that the description here is so broad that it would include people who are not the MS-13 people we're all talking about.
I'll just say this, I've looked
And Mr. Chairman, further, this has happened before. We have, in fact, prosecuted religious people, and that's why there's concern about this.
If they're engaged in criminal behavior, I'd encourage that. But that's not my point.
Well, sanctuary
That
has
is not the effort of what this is about. I've looked at, spent a great amount of time watching way back in the 80s and the 90s, the Los Angeles gangs. They have 8 or 10 major gangs and then break-offs of gangs where they take people and put them into what I would say, they didn't say groups of 5 or more, but groups of people that went out and did things. And I just think that this consistent behavior to use language, to use ideas that law enforcement's been used to, but this is gang activity. This is not an individual. And where you find that there's a group of 5 or more conspiring together to do things. So I look forward to any update if you want to get one, or to us about how we should further define gangs. But I will tell you, if the Secretary of Homeland Security comes back and tells us that, in fact, they're going to go after nuns,
Well, it
I
will,
think we'd be shocked.
if
think
I may,
they-
Mr. Chairman, it will not be in the Section 2 of the bill. It'll be Section 1 of the bill, and there's no reporting
It'll be in
requirement
the section where
in the first
where the
section.
Secretary of Homeland Security designates to Congress who those gangs are.
No, incorrect. Because we give, if this is law, we give any officer in the United States the authority to take any member of 5 or more who is committing some of the offenses defined in this, including having a false ID. Well, I mean, every undocumented person in the United States has a false ID, or else they couldn't work, they couldn't go to school. Now, we may be against that, but that is different than
Well,
being an MS-13 member.
I think what this is about, we know what it is, and I think any reasonable person would. Dr. Burgess?
Thank you, Mr. Chairman. And actually, your line of question pretty much answered any question that I have. I want to thank both of our witnesses for being here today, and look forward to the rest of the question and answer. I yield back.
Thank you.
Ms. Slaughter?
I'm sorry, no questions.
No
Thank
questions.
you.
Ms. Newhouse?
Thank you, Mr. Chairman. Thank you, Mr. Johnson and Ms. Lofgren for being here for this piece of legislation. I probably should start by thanking the chairman of the committee, as well as many of the members and the staff, for being attentive and listening to concerns that I've raised and working with me on this bill before we bring it to the committee. I just had a couple questions that I wanted to pose to try to demonstrate, hopefully, for my own satisfaction, as well as many people here and in Congress, as well as outside, what this bill is trying to accomplish, and maybe even more importantly, what it's not trying to accomplish. And so my office has been receiving lots of comments about this legislation, and some people are relating potential scenarios, some real-life scenarios about concerns about the bill. And so I don't know how best to do this, but I'd like to read a couple of these, and if, being good at well-trained attorneys, I'm sure your retention level is good, and I could get through a couple of scenarios before I'd have to stop. But if not, I can do them one at a time. But I'd like to do that and have you respond to these. And these are not, I should say, just dreamt-up potential things. These are real-life situations that I think would help clarify for me, and maybe others, at least some of the potential situations we may find. Now, there's a lot of scenarios we could go down, a lot of different things that we could talk about. I come from a state that, as you know, the state of Washington, as many others, have legalized marijuana. I think somebody talked about that. And so that could have potential implications, too, if someone is following a state law but could get caught up in federal law as well. So first of all, let me just start with something that actually did happen in my home state. And pardon me for reading this to you, but first, it was a very public case, and it was recently in the news, and that was an individual by the name of Daniel Ramirez Medina, a DACA recipient from Washington. He was detained by authorities for over a month. He had a tattoo symbolizing the city of his birth, which was a city in Mexico, which agents mistakenly thought was a gang tattoo, even though he was not a gang member, had no criminal history, had twice passed background checks in order to participate in the DACA program. He's since been released, but had this bill been in effect, the question would be, could Daniel have been deported simply because of his tattoo and mistaken identity? And I could stop there and let you both respond to that before I go on, maybe best.
Well,
You want to go first?
Well, I'm not familiar with all of the details
Sure.
of the case, but as you've described it, under this bill, if an officer had a reasonable belief, which is not a very high standard, to believe that the young man was a gang member based on his tattoo, and the gang was engaged in activity that violated any of the conduct defined on page 2 and 3, then yes, he would be detained for removal. And under the bill, he could not be bailed out. There's mandatory detention, so he'd still be there. Now, ultimately, eventually, you would get to an immigration, well, as a DACA recipient, he might not get to the immigration court if he'd been here less than 2 years, because there's another provision that is in play, which is something called expedited removal. In 1996, we enacted legislation, which I opposed, that allowed for removal without an immigration hearing if there was a belief that the individual had entered the United States within the last 2 years. I don't know what the status
So,
was of
yeah,
this
I don't have
young
all the
man.
details of this, but given what we know, I guess,
I think he'd still be in prison.
Mr. Johnson.
I would not disagree with that. I think he could be and would be put into removal proceedings under that scenario. But the important point is that the government maintains the burden of proof. ICE has to prove its case. They can't just go on this suspicion. They have to prove it up in court. And so he has all the rights to due process there, in addition to review on appeal. So he can go up to the Board of Immigration Review and ultimately into the federal court system, all the way through ultimately the U.S. Supreme Court if the case has merit. So there's a number of safeguards that are ensured there, and this is, I believe, a necessary amount of discretion that we have to give to law enforcement and to our system to maintain safety, and I think that the benefit outweighs the risk.
So the mere presence or possession of a mistaken identity tattoo would not necessarily.
Well, if I may, the problem with the government has to prove argument is all they have to prove is that they had a reason to believe. That's what they have to prove.
They have to ultimately prove, if you look at the statute, to detain them under this, is that you've got to show that he's either been a member of the criminal gang,
Right.
or that he's participated in the activities, and
To detain, but then the burden of proof falls on the government to.
exactly right. They have to prove their cases in any other.
Yeah. Okay, well,
I think we need some clarification, because I think it's quite clear that the statute, what the government's proof is to prove that they had a reason to believe. They don't have to prove that the guy is actually a gang member.
To detain him, that's right.
And to remove him.
But or for removal. But the safeguard is that you run it through the judicial review in the courts. And ICE, again, has the discretion whether to bring the charge or not. Once they do, then the court has to review it. And we trust our court system. We trust it through the appellate process and the security of due process to make sure this is done correctly.
One other additional point, the rules of evidence do not apply in immigration court. They're administrative proceedings. So the kind of due process we would expect in an actual courthouse is not present because the rules of evidence are not present. I'm sorry to interrupt, but I thought that was an important point to make, sir.
But can I just add one thing, that in the scenario of a mistaken tattoo or what that would mean, there are still standards of evidence that apply in these hearings. And even if all the federal rules don't apply in an immigration proceeding like this, there are safeguards in place, and he would be able to prove that that's not evidence of his admission in the gang, and that's what our system is for.
good, thank you. So scenario 2, different case, completely different. So this individual's name is Grace, an alien who works as a receptionist at a small business, was detained in a workplace raid by ICE's gang unit. ICE claims that many of her coworkers are gang members. She doesn't think this is true, but even if it is, she didn't know anything about it. When the ICE's gang unit arrested her, they noted in her file that she had been identified as an affiliate of an active in a gang because of her employment. ICE's allegation was based exclusively on her employer and the alleged gang involvement of her co-workers. So she denied gang involvement and has never previously been arrested. So in that scenario, is it true that if this bill were law, when Grace was arrested, she could be subject to mandatory detention and barred from accessing any available relief simply because of her job?
I believe so. The statute doesn't require that the member of the gang take all of the activities, just that they be a member of the gang or association. And in your scenario, I don't know whether she is unlawfully present or here on
That I don't know
visa
either, only that it says she's an alien.
But I think, given the bill has reason to believe, they have a reasonable belief, it's a very low evidentiary standard. You've outlined their belief, and I think she would therefore be incarcerated, to be removed under the statute. And unless she was here for less than 2 years, in which case she might not be,
Like the previous example.
she might not have the availability of a hearing at all, depending on how things proceed on the expedited removal, which is a moving target. And again, since there's no permission for release on bail or bond, she would still be there.
But wouldn't the burden of proof fall into this as well? And this, I guess I
Well,
shouldn't answer.
again, and I think we're seeing the statute slightly different, but I think a clear reading of the statute is the government has to prove they had a reasonable belief, not that the belief itself was accurate, but that they reasonably believed it was accurate.
I agree that we don't really have enough facts to make the determination. If she was admitted legally, then the reason to believe standard no longer applies to Grace. But I think, I don't disagree with everything Ms. Lofgren said, is that she could be charged as a gang member under that scenario if we make those assumptions, but she does get a hearing, and she is eligible for a bond, and again, it's the burden of proof that protects her here, and she has the right to go in and make her case that she was charged incorrectly.
There again, like I said, I'm presenting these as concerns that were brought to my attention and for clarification purposes. So let's go to the third and last. Maria,
Like
an
being in law school again. isn't it?
Yeah, really. I never had that privilege. Maria, an 18-year-old young woman, was granted asylum in the United States due to enduring ongoing beatings and abuse in her native El Salvador. She was a victim of brutal gang rape and abuse. The gang threatened her family and forcibly tattooed her to identify her with gang markings. So had this bill become law, had it been law, before Maria came to the U.S., could she have been barred from receiving any protection in the United States and sent back to El Salvador due to mistakenly identifying Maria as a gang member when in fact she was actually a victim of gang attacks?
Well, I think that one's the easiest of the three. If she could present herself at the border or any port of entry and request asylum based upon her fears, and she'll get a credible fear hearing, and at that point, a determination will be made about the legitimacy of her claim. So that's the way the system works. It works pretty well in that regard, and I think she would have that ability.
Okay, thank you.
I think that, first of all, the decision to admit is not subject to any review or appeal. And so if there is a reason to believe that a person is inadmissible, and as a gang member they would be inadmissible under current law, they would be denied. The scenario that you've outlined is she's already here, I believe, and she has asylum. And the problem is, under the statute, if an officer seeing that gang tattoo has reason to believe that she is affiliated, if you look at page, I'm losing track here, of the an alien associated with a criminal gang, then she's going to be removable. And once again, because of the no bond, no bail provision in the Act, even if she were here as an asylee, that matter would not be heard for a considerable period of time. It's one of the reasons why a lot of the advocates for victims of persecution have expressed concern about this bill. I think, as I'm hearing you, and I know that my colleague here is sincere, we all think that MS-13 is a problem. That's not the argument here. The argument is the specifics of the statute and whether we are throwing a rope over some things that we really don't want to do. And we're going to be giving discretion to thousands of line officers to make judgments pursuant to the statute that could lead to results that we're not going to be very happy with, even though all of us would be very happy with an MS-13 effort. So,
Mr. Johnson.
I just would respond to say that I think those concerns would be more better founded if we were giving all these law enforcement officers and ICE officers, unfettered discretion. But that's just simply not the case here. We have at least 3 layers of safeguards and due process here that will prevent that kind of abuse. If that were not the case, I wouldn't be here advocating for this bill. But I think it's well-written. I think it's very carefully drafted, and I think it will have the desired effect of going after these dangerous gangs. And again, we all agree on that. It needs to be done.
Yeah, and I would agree on that, too. You talk about large cities and suburban. I live in a very rural district, and let me tell you, gangs have been a terrible problem, even up into the current time. It's not just a past thing. This is happening right now, and we need to do everything we do. My whole state and federal legislative career have been supporting gang legislation to try to get a handle on this, and certainly look at this as potentially could improve by giving necessary tools to law enforcement agencies that they don't have. And I think, listening to you, Mr. Johnson, that some of the scenarios, at least in my reading of the bill and a lot of discussions that we've had over the last few days about it, some of these things are perhaps certainly valid concerns, but I'm not clear that the concerns are present in this piece of legislation. That, as you say, and I would let you expound on that if you'd like, that there are processes in place to protect individuals. There may be reasons to detain, but not reasons to deport because of the burden of proof that is present and necessary that is placed on the federal government. So if you have any further comments about that, it'd be
Well,
happy to.
I just to say that at some level, we have to have some faith in our system that it will be done well and right. If it's not, we can always come back here and amend the statute in some way, further tighten it. But I think that the language that is presented to you is tight enough to have those safeguards and protections in place. And so for that reason, I think it's a bill whose time has come.
I would, if on the first point you raised, because my state also, the voters also approved marijuana. If you take a look at line 19 on page 2, our constituents who persistently use marijuana, which is allowed under state law, are going to be in violation of this. And if there were a group of, 5 like-minded individuals, they're a gang under this statute. I understand we like to think that we'd never have, a problem in the execution of the law, but you can never say poor drafting of a law is going to be cured by prosecutorial discretion. As a matter of fact, we've just heard an administration that's objected to the idea of prosecutorial discretion. So I think it really is incumbent on us to make sure that these measures are tightly drawn and directed only at what we want to get at, and I don't think you can honestly say that about this bill. But that's my view.
It seems like, and again, I'm not an attorney, but looking at some of the definitional language here that has been taken from previously written federal definitions, it does cover quite a few different things that have to happen before someone is determined to be a gang member. And so just sitting around smoking pot in your living room, it probably doesn't qualify, my guess is, but...
Well, if you look on line 11, there is really the discretion, which is the first section that I've been objecting to, and then at the last word on line 11, page 2 is or. And that really goes to the bifurcation of the bill I talked about earlier. You've got the first provision, which is whatever some guy in a uniform thinks about somebody who he thinks is doing the wrong thing versus this elaborate process, and you can use both. And I have problems with the second section, but the first section is really, it's very loose, and it's going to lead to problems that will bedevil all of us on a bipartisan basis, because it's not going to be about MS-13.
Would just add a comment, when you're talking about felony drug offenses, I'm not sure there are many categories that would fit that definition. With marijuana, for example, I think you would have to be selling it in large quantities or transporting it across state lines, things that are clearly unlawful to qualify.
But if I may, that's not correct, because if you have multiple possession, that can be a felony. And remember, you don't need a conviction under this. You just need to have done the act. So if you possess marijuana on 15 different occasions, that's going to be, if that had been convictions, it would be a felony. But this statute, this bill, does not require an arrest or a conviction for the determination to be made.
Well, it was just pointed out to me that for almost 2 decades, any alien who's involved in drug crimes of any type is deportable on that basis, or at least they go through the process to be. And I think just at some point common sense has to apply here, that ICE is so overwhelmed with the tasks that they have before them, and we all know that. I just don't think that we're going to have ICE officers out, picking on, teens who are sitting around to smoke marijuana. I think they have much more important violent offenders to go after. That's what this bill is for, and I just don't believe that it's going to be abused in the way that is being suggested here.
Well, again, I appreciate the debate here. I think it's been helpful to me, and I'll defer back to the chairman. But I think it's important that not only all of us understand the nuances of this language, and other outside groups as well. So this has been very helpful, particularly, but I think, explaining the intentions, the goals of the legislation, what those are, but like I said, just as importantly, what they are not. And so I appreciate that very much. I appreciate your both of your comments and input here. And like I said, this is a serious problem, as everyone knows, around the country, large cities, small towns, and rural areas as well. And so addressing it is something very important for us to do. Mr. Chairman, I yield back.
Gentleman yields back. Gentleman from Massachusetts.
Yeah, well, let me just say, we all think MS-13 is bad, and we all want to deal with it. But listening to the exchange between Mr. Newhouse and our 2 witnesses here, I think it reinforces the point I made at the very beginning here, and that is we should have had a hearing. Mr. Johnson, you say this is carefully drafted. We already have one. The chairman of the committee has already sent us up an amendment to correct the original bill. We're doing it we're going to self-execute it. We're not going to have a vote on that. I don't know how many other errors are in here, but I don't quite understand the rationale for not doing this the right way. I get, Mr. Newhouse talked about, that this bill is, trying to understand what this bill is trying to do. I guess, I think everybody's trying to, get at these illegal gangs. But that's the question we ought to be asking ourselves: is, does this bill do this, or are there unintended consequences? We get a slew of letters from human rights organizations, from legal organizations, and faith-based organizations, all raising all kinds of questions. And this exchange that I just heard happen doesn't seem to give me any comfort that anybody really knows for certain, whether or not there could be consequences that may not be intended, but are very, very, very real. And the idea that, well, if this doesn't work out right, we could always come back and fix the law. How about doing it right the first time? You mentioned that we took this up in 2005. Well, it's 2017. That's 12 years ago. I'm sorry, I don't really feel comforted by the fact that Congress voted on this in 2005, and therefore, we don't need to revisit it. I don't know how Mr. Johnson, you or the Judiciary Committee can come here with a straight face and say, we want to close rule. I just don't get that. We can, we obviously have differences of interpretation about specific language here, but I mean, maybe there are ways to tighten it up so that people on our side don't feel as uneasy about it, that are totally consistent with what you want to do. But we're being denied that opportunity. And so, I mean, again, I think a lot of these issues could have been resolved if you went through regular order, if you had a hearing and a markup like committees are supposed to do. And if you didn't want to do that, you ought to come before here and ask for either an open rule or a structured rule, or at least allow some amendments to be made in order. But this, again, this is part of a pattern here where the majority is embracing an appalling process, and at the end of the day, it results in bad legislation, because I'm a big believer that bad process leads to bad legislation, and there's no reason why other voices can't be heard on this. And so I don't expect you to contradict the chairman of your committee, but it is frustrating. And maybe all that happens is, you guys pass it through the House, and then it dies in the Senate, or maybe that's what we can hope for here, but it's kind of wasting our time if that's the case. But this process stinks, and so I yield back I yield to the gentlelady from New York.
I appreciate that. As just sitting here this afternoon, I've known about MS-13 for years, we know. Am I correct in my assumption that we deport them and then they come back? Isn't that generally accepted a fact?
We hope that they don't, and in fact,
But don't we know that they do?
that has happened in the past, although with increasing irregularity, we've made it very difficult for people to get back with the increased presence on the border, the increased technology, and the like. It's much more difficult to enter without authorization than it was in the historic past.
Well, if I don't want to ask you to put a percentage on what number you think would come back, but if what we're trying to do here today is just to get them out of the country, it appears to me, I think I would have to agree this bill is very poorly written, because not only are you just deporting people, you are throwing a much wider net, and a lot of people could be picked up who are nowhere near a gang member. We need to be more precise than that. And I certainly agree with Mr. McGovern. We've been saying this over and over again. We almost never see a bill that's gone through committee. We have no idea. We can't say, how did the minority feel about it? What did they have to say? We all know why this bill is here, and we're not messing around with that. But if we're going to do one, I would think we would at least try to have an idea that we have written a bill here that makes some sense, and it will at least come close to doing what it is that we want, which is freedom from gangs. And that doesn't mean picking up everybody from the same neighborhood or whatever we might be pretending to do here. Does that make any sense to you? So
It does
would
to
you-
me, yes. Well, I think if you look at the first section, the designations, it's too loose. The 5 or more people who do certain offenses, and we may or may not approve of those, quote, offenses, but even if we don't like that someone has false ID so they can work, that's not MS-13. I mean, I think we all agree it's a different type of activity, and as the police told me in my office this afternoon, gangs are a problem. Stuff like this doesn't help.
Doesn't help. Mr. Johnson, don't you feel, well, I don't want to put you on the spot. How do you feel about how the bill is written? Do you feel it's specific enough to do what you want it to do?
I do. My background's in constitutional law, and I read these things very carefully. And I do think because we borrowed this language from pre-existing language in the criminal code that's, again, dating back to at least 1994, I haven't, we don't know of examples of this language being widely abused that way. And your concern about the reentry is valid, and that's why we We passed a bill which increases criminal penalties for reentry by criminal aliens who have been removed, but we have to remove them first, and then hope that our system works.
If
Well,
I may,
Of course.
Ms. Slaughter, the problem with seeing an equivalence with the criminal law defining gangs in here is that in the criminal law, there are rules of evidence, there's an opportunity to be heard in a prompt fashion. That's not the case in immigration law. And also, in criminal law, in immigration law, and if this bill is adopted, what you're proving is that your belief, that you did in fact have a reasonable belief, not that, in fact, the person was a gang member. And so that would never flow in criminal law. That's not how due process works, but there's no due process when it comes to this first section of the act. It just isn't there. Well, maybe we don't care about due process for gang members. I think it's actually important that due process applies to everybody because it's in the Constitution.
Exactly.
But certainly, if you end up deporting people who are legal permanent residents of the United States, and let's think who that is. And those are people who followed all the rules, they've got a green card, they are permitted to legally live here for the rest of their lives. They own businesses, they own houses, they're married, they have kids and grandchildren. I mean, they're Americans, they can apply to become citizens after 3 years if they're married, or 5 if the residence was gained not through marriage to a U.S. citizen. So these are people with substantial roots, and to be able to say, we're going to kick you out because we had a reason to believe that
You don't even have to state what that reason is?
that you are with 5 people who, for example, committed the act defined on line 19, a felony drug offense. No arrest, no conviction. You're using medical marijuana for your epilepsy. You do it 3 times a week for the last 6 months. That's a felony drug offense under the federal law, and we're going to deport you.
Can I just add?
Of course.
Just a little clarity. First, I think it's important to point out the Supreme Court's ruled that the due process required by criminal cases is not constitutionally required in civil removal cases for aliens. But here's the overall point. To say that there's no due process here, to me, is just an inaccurate statement, because once an alien's been charged here, the charge has to be proven by evidence in court, on the record, in immigration court. That is the due process here. That's the oversight to ensure that it's not being abused.
Well, how can the two of you have such a difference? And Zoe says that they can't. Is that,
No, well, there's 2 provisions. One,
Okay.
which is easily refuted, the consular officers answer to no one. So we're changing the rules as to who is a quote gang member and who can be denied. There's no due process there. Our former colleague, Barney Frank, always had a bill that was always bipartisan to have some review of that decision, but that's not before us today. Then there is the removal provision. You're right. There's no due process similar to criminal law because this is a civil procedure. That's why these individuals also don't have lawyers. So they're there. The government has to prove they had a reasonable belief that they were in a group of 5 that did any of the identified activities as a primary cause. That's not too hard to do. It doesn't mean that you've proven that they're a gang or they're an MS-13 person.
But if the person charged denies the charge, the burden shifts right back to the government, and they must prove the allegation. The officers at the ground level don't have the unilateral authority to send somebody out of the country. It's got to go through this process, and that's the whole
well,
point.
let me tell you why I'm worried about this. ICE, I know you mentioned we should be able to trust ICE, and we should. And I wish we would, but I think unless due process is followed, how do we know? We were going to have a ferry between Rochester and Toronto, and ICE moved in there. The ferry died, and ICE left. They stayed with us. And they come to the airport. I see them oftentimes. I'm going there just looking for people. And they never seem to approach anybody that I know of. And I've heard that in parts of my farming areas, farming is very big in upstate New York, that they will often stand outside churches on Sunday because they can pick up people. And they pick them up with no cause at all. I mean, coming from church is not an offense. And there's been a lot of consternation where I live up there. At some points, they were even able to stop trains and go in and interrogate people on the train. So I really believe that is not really following American law.
Well, if,
Now, I'm not a lawyer, and I'm first to admit it, and I've certainly, the only thing I pointed out to you that I know about MS-13 is they're dreadful, and we send them out and they come back. But I don't want to catch up a lot of other people who are totally innocent.
we don't
and throw
either.
them out.
We don't either, believe me.
I yield back to
I
Mr.
th- I
McGovern.
th- Let me just conclude with the point I've been trying to make. It would have been nice if you guys had done a hearing and done a markup. It would have been nice if the police officers who Ms. Lofgren referred to had an opportunity to testify. I think you might have been able to come to this committee with something that was truly bipartisan, that there wasn't as much controversy over. I have no idea why the leadership of this House wants to run this place the way they are without going through regular order, but that's the choice that's being made, and I think it's a lousy process. I yield back.
Gentleman yields back. Gentleman from Georgia, no questions. Gentleman from Florida.
Mr. Chairman. Mr. Johnson, I don't profess a background in constitutional law. I just went to law school, and I studied constitutional law and passed, but I've seen a lot of provisions over the course of 53 years as a lawyer, including a considerable amount of immigration circumstances. You were not here in 2010, were you?
No, sir.
Have you read the provision in 2010 on immigration reform that my friend Ms. Lofgren and yours and countless others had something to do with? And do you think that it would be wise for us to do immigration reform than to do these incremental steps?
I agree. I think immigration reform is something everybody's on board with. The devil's in the details, Judge, as you
Okay,
know.
then let's talk about that devil for a moment. Are you comfortable with secret evidence being offered in this particular measure, allowing people to be detained? You comfortable with that?
I don't know what you mean, secret evidence.
Well, Ms. Lofgren, maybe you can help him understand the provision that's in here with reference to that.
Well, first of all, the ICE agents don't have to show any evidence to the person they're bringing into custody.
Right.
They have to have a reasonable belief. They do whatever they want. Under the provisions of the Act, that person may not be bailed out. It has nothing to do with whether they're a flight risk, whether they're a danger to another. If they are detained pursuant to this bill, they are not permitted to be released.
But then in the Secretary's ability to deal with the matter, page 6, under B, the Secretary may consider classified information in making a
correct.
designation under this subsection.
Well, that's actually very interesting, because I focused in on the first section,
All right.
not the provision after the or. But since, if you take a look further on page 11, line 7, a person who is in removal proceedings pursuant to that designation has no opportunity to actually challenge the designation, whether it's based on classified information
Or
or
not.
public information.
That's correct. And in addition thereto, I find it passing strange that section, you keep referring to it, and I agree with you, Ms. Lofgren, as the second section of the bill, this designation and review of designation and potential for revocation. So the Secretary makes a determination that this is a gang, and then he has a certain, or she, a certain amount of time. And how many people do you think are going to show up and read the Federal Register and then pursue their rights under revocation? And even if they do, the time period is first 2 years and then potentially 5 years. It just goes on and on and on. This is unconstitutional, Mr. Johnson. And I think it will be borne out, and you and I will have an opportunity to discuss it over the long time. But I want to ask you a couple of specific questions. Is this measure, since all of the talk around it seems to be about MS-13, is it directed at MS-13 exclusively?
No, sir.
Or would the Russian mafia be included in this?
Of course.
I see. Well, we didn't have much media attention to other gangs. I thought Mr. Newhouse did an outstanding job in pointing to the anecdotal situations, and I was uncomfortable with your answer about the child forced to have the tattoo on her body escapes. Let's say you're forced into the gang, you escape the gang, but you have a notebook that has doodling in it, or you threw a bad sign and somebody has reason to believe you may be in a gang, then you're in the milieu at that point. Am I right?
It's possible, but then all of your due process protections kick in.
I question your concept with reference to due process in administrative proceedings, but clearly the First Amendment rights of individuals in some respects abridged. In my view, what this can allow for is the dragnet type situations. When you began your presentation, you indicated that there were 10,000 members of MS-13. I don't know how you know that. I don't know what the criterion is, but I do know this. In every one of our communities, there are gang task forces. And in my considered opinion, we don't need this particular law to go after members of MS-13 and or deport them if they are convicted. I, for the life of me, think it's more than a waste of time. Now, back to process for a minute. And I do mean to be facetious here, but there is currency to what I'm about to ask you. This is Ms. Comstock's original legislation with Mr. Labrador, Mr. King, and I forget who the fourth person was.
Mr. Goodlatte.
Mr. Goodlatte. Oh, yeah. Who is going to self-execute language that I want to make sure that you get him and everybody else to tighten up on the technicalities, because he wants to excise or remove the outstandingly wrong a notion of reason to believe. But let me continue. I don't, with you as their representative here, I don't hold you to the standard that I do of the scriveners of this legislation. But do you have reason to believe that any of them talked with the Homeland Secretary or with the Attorney General or with attorneys general or writ large? Do you know of any basis that this legislation comes to us this day without having had a single hearing, mock-up, or anything along those lines? So what is their basis? Is it just this strong feeling that all of us have about MS-13 and any other kind of gang that is wreaking havoc in our respective communities?
My belief is that was the genesis of it, but since that idea came about, I think there have been a number of discussions, deliberations, talking with persons in the Department of Justice and ICE agents at the ground level and all the way through the process. The White House has weighed in favor of the legislation, I believe, and you know, when you were talking about the data, the statistics on MS-13 numbers, that came straight from a Department of Justice fact sheet on MS-13 that came out April 18th of this year. So there's a lot of data that is behind this legislation and supports it, a lot of you know, those who are the practitioners in the field who are dealing with this, and there is some frustration at the ground level that when they know that someone is part of one of these dangerous gangs, MS-13, Russian, Italian, of whatever origin, from wherever, they know, these people know a gang when they see it. They're not after, with all due respect, teenagers smoking marijuana. They're after the dangerous people who are causing havoc on the streets of this country.
And, Mr. Johnson, sometimes they make mistakes.
Of course they do, and that's why
And
they
we
do.
just saw a glaring example of that in an unrelated type situation, not an alien, a United States citizen, nurse, doing her job in Utah, and the police go in and ultimately wind up arresting the lady. Now I'm here to tell you that most ICE agents, most police officers, most administrative judges, most people involved in law enforcement follow the law. But there are a lot of people, because there are so many of them, who do not. And there are people, for example, the man that was just pardoned by Donald John Trump, Arpaio. You give him a law like this and then see what the end result will be. He was already racially profiling people, and it would be just a matter of time before he would undertake to do the same thing. I have a concern about that. Ms. Lofgren?
I just wanted to note that thousands and thousands of people have been deported because they use marijuana. So to think that this would not be of interest to ICE agents, I think is belied by the history, number one, and this would be an additional tool to make them, you wouldn't have to prove the use. You could all approve the association with people who use it. So to think that...
Therein lies the problem. Ms. Lofgren, you come from the area where the gangs, the Crips and the Bloods, they throw signs and kill each other about colors. I'm concerned about domestic gangs just as much as I am about MS-13.
Sure.
And trust me, these people are particularly dangerous, and so are these people that are domestic gangs. In Chicago, for example, or in South Florida, where I live, there are gangs. And are we going to give these people the necessary resources? I mean, the ICE agents and the police officers who come in contact with people, are we giving them the resources that they need in this legislation?
Well, this legislation, as you know, is very specific for aliens involved in gang activity. I would agree with you that we need to improve resources to law enforcement, but again, those are different measures for different times. This is a very specific problem that we're trying to attack based on very specific evidence and obviously a crisis that we have in this country, and we feel like it's a good step in that direction.
Well, it raises serious questions of judicial review of government designations of certain groups, in my opinion. It also serves as a bar, in some respects, to humanitarian relief for individuals in violation of international treaties. And I guess Mr. McGovern was right. Whatever we do here, and we'll pass it on the floor of the House, I'll vote against it, and it'll go to the other body, that big black hole over there on the other side of the Capitol, and it will die. Thank you. I yield back.
Gentleman yields back. Before I go to the gentleman from Colorado, I want to announce that the votes are getting ready to be called. There is only one vote, and the intention of the chair is to continue this hearing, and so everyone is on notice to go vote, and we'll continue the hearing. So just there's just one vote in this series, but I wanted to let everybody know that. And with that, the gentleman from Colorado, Ms. Polis.
Thank you. I just wanted to ask Ms. Lofgren to elaborate on, and it came up briefly, where, as we know, nearly everybody who's here who lacks documentation has some type of identity or social security number that they use for employment in violation of our law. Obviously, that doesn't mean that they are gang members or about to cause any crime. In fact, all of the various immigration reform proposals that have been bipartisan have certainly included people that had been using false paperwork. So I guess my question is, how does this proposal pull in essentially everybody who's undocumented,
Well, if
who
you-
is either presenting a false social security number or false identity.
18 U.S. Code 1028 relates to fraud and related activity in connection with identification documents and the like. That is, someone knowingly possesses with intent to use unlawfully or to transfer unlawfully 5 or more identification documents other than those issued lawfully for the use of the possessor, authentication features, or false identification documents. That is easily applicable to tens of thousands, if not hundreds of thousands, of people who are here.
And if that could mean, if I could say what the case, so this might be somebody who has one social security number, a different
Right.
photo ID. So it could be 5 different ones that the same person
Right,
has.
and if you take a look at page 3 of the bill,
Yeah.
line 6 down to line 9, that's the provision that makes this a crime that would be the predicate for gang activity.
Yeah,
along with
and,
the-
and of course, while we agree that that's illegal, that is a far cry from gang activity. That's a different.
Correct, I mean, that, we're not saying that that is a lawful activity, what we are saying is that's not MS-13.
Yeah, it's entirely different. Okay.
I think it's important also, just to briefly mention, the due process that's been referred to here repeatedly, that even if there's a low standard for the detention and apprehension, we don't need to worry because there's all this due process. Due process in the context of immigration court is minimal at best. Immigrants who are in the proceedings do not have appointed counsel. They have a right to counsel if they can pay for it, but most are unable to pay for it. There are no rules of evidence. Whatever you want to make up, you put into play. There's mandatory detention of this bill, and that prevents the release of immigrants in detention, so that due process issue is removed. Many of those who are detained don't speak English, and so they don't even know what's going on in the proceedings where they are being held. And the hearings are conducted with terrible conditions. I know many immigration judges. It's a hard job, but they have no support, and the caseload is crushing. They are running through these cases at a pace that is astonishing. So when we think about the due process that we see in our American civil courts, don't think that's what you're seeing in immigration court. It's not.
I just, look, I want to add that the government has to convince an immigration judge of its case. And the suspected gang member has the right to appeal that to the Board of Immigration Appeals and ultimately to the federal courts and all the way up, as we said, to the U.S. Supreme Court if it's merited. So while the immigration courts may be overwhelmed, we have all these processes in
Well,
place.
I guess the part I'm confused about there, if I may, is the definition that Ms. Lofgren quoted from, said that they have 5, if they meet that criteria of having 5 IDs, they would be found to be covered by this law. That is used by this law as a proxy for gang membership, even though that defies common sense. So that's my question. I mean, if they were technically meeting that definition, the state could prove that. It doesn't mean they were a gang member. It just means they had 5 pieces of wrong identification.
I hear your concern. I just believe that at all these various processes, if something defies common sense, then the courts will find that to be the case. And if not, the appellate courts will find that to be the case. I just don't believe that this is going to be subject to the abuse that is feared.
Gentleman from Colorado yields back. The gentleman from Colorado, Ms. Buck.
Thank you, Mr. Chairman. Mr. Johnson, there's been, I think, some confusion about your earlier testimony. Was this bill a part of a larger bill that was introduced in 2005 in the 109th Congress?
I believe that the primary content of the bill
Yes.
has been part of a larger piece
And
of
was there a
legislation.
markup in 2005 on this part of the bill?
There was,
And was there a hearing on the subject matter of this part of the bill?
There was, yes.
And was this bill also considered, or was the content of this bill considered in the 113th Congress?
It was.
And were there hearings on this, the content of this, or the subject matter of this bill?
Yes, sir.
And was there a markup on the subject matter of this bill?
I believe so.
And in the 114th Congress?
Yes, sir, same
And in
thing.
fact, in the 115th Congress, in the Judiciary Committee, you sat in committee and heard and witnessed the markup on this bill, or the subject matter of this bill?
We did.
Okay. Mr. Johnson, you've been on the Judiciary Committee now for 8 or 9 months?
Yes, sir.
And have you witnessed on the Judiciary Committee a sense of congeniality or collegiality, either one, when it comes to getting to the point and working together on making bills better? Or have you witnessed discussions about Russia interference in an election when we're talking about immigration bills and every subject matter imaginable, other than the subject matter that we're supposed to be dealing with in judiciary?
It's the latter.
So when you hear conversations about, why aren't you guys just getting to the point of this and working hard with the other side and get it right the first time? What kind of, do you laugh inside?
I don't laugh, but I do. Mr.
I
Buck
do.
is right. We spend a lot of time in judiciary. We do a lot of hearings, and we've worked through a large amount of legislation in relative terms to other committees. So I'm not sure how we could dedicate much more time than we do.
If I may, just in defense of the Judiciary Committee, I've been a member of the committee for 23 years, and there have been times when we have had very contentious deliberations. But there have been many times when we've worked collaboratively on issues. So certainly, it is possible for us to work together and write good legislation. In my opinion, it did not happen in this case, but to think that it could not happen, I think, is a mistake, if I may offer that.
Our friend from Colorado yield just one moment.
Sure.
The question that you put with reference to the measures previous that were undertaken, that had hearings, that was not this bill. This bill was introduced last Thursday.
I understand, but the subject matter of this bill has been discussed in committee before. And Ms. Lofgren, I have to just say one thing in response to your comments. I have a huge amount of respect for you and the way you conduct yourself in Judiciary Committee, and I did not mean to impugn your integrity at all. I think that consistently you have worked across the aisle, and I have been on your side in a number of bills, and proudly so. But Ms. Lofgren, I wanted to ask you about your comments about, you seem to say over and over again that the police officers would be given discretion on the street to make certain decisions. And I may have a different experience with police officers on the street than you do, and I just want to go into that for a little bit. Have you done ride-alongs with police officers?
Oh, of course.
Okay. And have you done ride-alongs with police officers that were on gang task forces, as the Judge Hastings mentioned earlier?
Well, ordinarily, in San Jose, they would prefer that non-commissioned personnel don't ride into the gang-infested areas with the police. They consider it hazardous.
Okay. Well, I was with the police in a number of areas, and I have to speak about my experience with the Greeley, Colorado Police Department task force, as well as the Weld County Sheriff's task force, and their work with ICE. And they have very specific criteria, and I imagine you would agree with me that they have very specific criteria in terms of identifying gang members. And you're familiar with the case law on retaining intelligence files that police officers and police departments have, that they can only retain them for a certain period of time, and they have to follow certain very objective criteria in that, in pursuit of retention of those documents. Is that your understanding?
The point I'm making, if I may,
Could you answer my question first and then tell me your point?
Yes, there are criteria, and we're changing the criteria in this bill. That's the point I'm making.
Okay. And so those criteria to identify a gang member include tattoos. Is that correct?
I think they do, along with certain other indices. The point is, this bill changes those indices, and I'm not attacking the ICE agents, I'll just quote the police officers that came to see me this afternoon, asked me to make sure this bill didn't become law, because most of the anti-gang activity, to be frank, is engaged in by local police departments. Thousands, tens of thousands of police departments are on the front lines of fighting these gangs. Obviously, the ICE agents are important partners in dealing with the international element of this. And what we've said on page 2 and 3 of this bill is that whenever you have 5 people who engage in the activities, they can be, the officer on the street can decide they're a gang subject to removal. And that's different than the current criteria.
And you understand that there are certain objective criteria that police officers use on the street to determine if someone is a gang member.
They also, local police,
Is that a yes or no?
they also have to arrest and convict, which is very different than in this immigration proceeding.
And there are certain jurisdictions that prohibit, and we call them sanctuary jurisdictions, that prohibit local police officers from working with ICE on international gangs. Is that correct?
There are a lot of police departments who do not want their officers to enforce immigration law. They want their officers to enforce criminal law.
And so if an officer came upon a gang member with an MS-13 tattoo who identified himself as being from El Salvador and in this country illegally, that police officer would be prohibited from contacting ICE and asking ICE to help remove this person from the country.
Well, I can't speak for the thousands of jurisdictions in the country, but I think if you had a gang member who needed to be arrested, that officer would effectuate the arrest.
And I'm talking specifically about sanctuary cities and a gang member that, under this bill, could be turned over to ICE for deportation, but has not necessarily committed a crime under the police officer's jurisdiction.
Well, we don't have the sanctuary bill before us. We had that up a couple of weeks ago. But I'll just quote the officers who came in to see me today, and they were from California. They said, we don't want to be immigration police. We want to be police. And they asked that we defeat this bill because they said it will get in their way in the job that they are doing. I do think that collaboration, I'll just give you an example from California. A few months ago, the sheriff in Santa Cruz County was asked by ICE to do a gang abatement effort. And so his officers went out with the ICE agents to go get the gangs. What they did instead was an immigration roundup that had nothing to do with gangs. And so the sheriff said he will never again participate with ICE because now his officers are mistrusted in the immigrant community. They can no longer get people to step forward as witnesses. So where they were very happy to participate in the gang abatement, it was bait and switch for them, and they no longer trust ICE or the things that they say. It was very disappointing.
Ms. Lofgren, I'd ask you to ask those officers next time they're in Washington, D.C., if they would come and visit me, because I have to tell you, I haven't met one victim yet that cares a whit whether a criminal harms them, whether that criminal is from this country or a foreign country. They care that they are being harmed, that they have been assaulted, that they have been burglarized. And if a police officer says to you that they want to be police officers, not immigration officers, we're giving police officers a tool in this case, and that tool can be used to reduce crime in a community and reduce the number of victims that we have in a community. And I would suggest that those police officers care very deeply about whether we have more victims or less victims, and any tool that can be used to reduce crime is a positive tool for police officers. So if you would send those police officers my way, I'd appreciate it. Do you also know that there are police officers use admissions by gang members as a criteria for determining whether someone's in a gang?
Well, you have to have meet your evidentiary standard, but certainly an admission against interest can be used as a piece of evidence, of course.
Well, and we call it a confession sometimes, but do you also realize that there are a number of gangs, in fact, most transnational gangs, that it is a violation of the gang code to not admit that you are a member of a gang when you're asked?
Well, If I may, Mr. Buck, I mean, we serve on the committee together, and I appreciate your questions, but I'm not, with due respect, understanding what they have to do with page 2 and 3 of the bill
And I don't
before
understand what
us.
Russia has to do with half of the things that we talk about, but it's a fair question, and I wish you'd answer the question.
Well, what was the question again, sir?
I asked you if you understood that an admission by, or a confession by a gang member is a criteria that police use, and I think you answered yes to that. And then I asked you if you understood that gangs have sanctions against members who do not admit that they are members of the gang, who deny gang membership.
Gangs do terrible things, and I mean, they punish people, they beat people up as initiations, they threaten people. You're not going to find my colleague here is the witness stand, Mr. Johnson, or I defending the gangs. There's no disagreement on this score among the parties or among any of the members here.
Well, let me ask you this, because there may be a disagreement on this, Ms. Lofgren. Do you, is there any bill that you can conceive of that you would vote for that would be, that would allow gang members to be deported?
Oh, no doubt there is, and in fact, we do deport gang members today. That's not, it happens all the time
So
today.
what would that bill comprise, what would be in that bill that you
Well, I
would,
can't
that you would
draft it,
support?
I can't draft it here, sitting here at the witness stand, but I'm confident that if we sat down, if we reasoned together in a bipartisan way, we could come up with something that was effective in the fight against gangs, that prevented unintended consequences, and met the requirements of the thing that we hold most dear, which is the requirements of our Constitution that we all take an oath to uphold.
And have you ever offered such a bill?
I don't believe I have drafted such a bill, but it would not prevent me from working with you to do so.
I look forward to that. Thank you very much, Mr. Chairman.
Thank you very much. I want to advise our, evidently no other member seeks time. Both of you need an opportunity to go down and vote. So I want to thank both of you for appearing before the committee today. Please remember anything you brought in writing would be available to our awesome stenographer. And Ms. Lofgren and Ms. Johnson, I want to thank you very much for being on the first panel here today. Thank you very much.
Thank you.
Jackson Lee, have you had a chance to vote? Yes, sir. The gentlewoman has. I had seen the gentlewoman out in the hall, and I knew that, but I wanted to make sure that we confirm that for the committee, because we have people that always want to make sure we're offering the same confidence to everybody. Gentlewoman, if she would be welcome to join us today. Is there any other member that would seek to be a part of a panel, this second panel? Seeing none, the gentlewoman from Texas is welcome to the Rules Committee. Anything the gentlewoman brought in writing will be entered in the record without objection. Gentlewoman's recognized.
I thank the Rules Committee for its courtesies.
Yes, ma'am.
And I serve on the Judiciary Committee as a ranking member on the Criminal Justice Committee. I've served on the Immigration Subcommittee for as long, I believe, as Congresswoman Lofgren, who serves as a ranking member of that committee. And so I'm here on the aspect of the criminality. I am here, thank you, Mr. Hastings. I serve as the ranking member of the Criminal Justice Committee, so I'm here on the aspects of this legislation that deal with criminal aspects and definitions. So I thank and I have 4 amendments. I thank the Rules Committee for its courtesies and its courtesies for accepting the filing. Let me read Section 521. It's been subsequent, 18 U.S.C. 521. It's been subsequently modified, but it had a definition of criminal gangs for a period of time, federal felony involving a controlled substance with a maximum penalty of not less than 5 years, a federal felony crime of violence, that is an element, the use of attempted use of physical force, and then I think it went into continued physical force, and in circumstances described in this section are that the offense described, and it goes on. But I just want to emphasize those elements. And the bill that we have before us seeks to expand a list of definitions that would warrant the actions that are called upon in this bill. So I will give you my general framework for the concern and opposition to this bill. I tried to probe it to see whether there are any limits on whether someone is 13, 14, 15, or 16. As I said, I'm ranking on the Criminal Justice Committee. We do a lot of work on juvenile justice. And by the way, we do it in a bipartisan way. I've worked with the chairman of the committee and the ranking member of the full committee on criminal justice reform or juvenile justice reform. So it's a misnomer to suggest because we are passionate and we have issues that cause some disagreement, that the Judiciary Committee does not have those moments. This bill expands the authority of Homeland Security, which I'm on the committee, and puts it in the context of acting on criminal issues. And so let me just suggest these amendments. I don't see any infrastructure, any firewalls that suggest that a 13-year-old or 14-year-old could not be caught up. Now, I don't want to diminish MS-13. I come from Texas. We've been dealing with MS-13 for a very long time. I've been dealing with gangs for a very long time. Before I came to the United States Congress, I was dealing with gangs in Houston, meeting with gangs in Houston. I might have been one of those local elected officials that really liked the midnight basketball because I actually got gangs that probably were not MS-13 to leave the streets and come to the parks and play basketball. And I understand that those who were debating it up here thought it might have been frivolous, but I can tell you the local guys like myself at that time felt it to be very effective. So there is no firewall for that. So my amendments speak specifically to this criminal matching and meshing between Homeland Security and the expanded duties of ICE officers and then mixed with police officers and the lack of the firewall around very young entities. The First Amendment deals with the idea of perceiving to be with gangs and therefore you could be hanging out. I guess it disturbs me to read in the first section 2, the term criminal gang means an ongoing group, club, organization, or association of 5 or more. But my First Amendment asks for a set of standards, if you will, to assure that we have a standard by which we would put these young kids in the realm of being deported, taken away from their families. We all know the history of gangs in some instances. Again, I'm not diminishing MS-13, but we know the psychology of gangs is family, belonging to something, and those younger individuals can be part of that. The Second Amendment proposes that where a designation is made for a criminal street gang, that such designation may not exhibit a discriminatory effect, absent a showing of a uniform legal standards as the basis for detention. So it builds upon the First Amendment, which is asking for a uniform legal standard, because as I listened to the discussion, we've added elements to elements already existing, and some of these, I think, have a frailty to them that young kids or 18-year-olds or 19-year-olds could be seen as in the wide net that this particular bill has with no options. Yes, they may be undocumented, and so I think that is really the key element, is just to add another measure of deporting individuals, or as I heard my colleague said, individuals who are in fact do have a green card, have a status here in the United States. My Third Amendment sets a clear and convincing standard of proof where an individual is designated as a criminal street gang, to ask for that. And the Fourth Amendment increases the number of individuals required in a group, club, organization, or association that would trigger a designation for criminal street gang by Secretary of Homeland Security. The present number is 5, and I hesitate to say you might have 5 friends that may have a tattoo or two. I think when we're dealing with the level that this might reach, the broad net, that we need a better definition, legal standards, and we also need a question of preventing discrimination when the Homeland Security Department is drawn in to designating criminal gangs and therefore taking this wide net to sweep up individuals that are in fact able to be redeemed. One of the other elements of my last amendment, besides, is to say that you're talking about past acts. And so my concern would be, it should be current acts, because people can get out of a gang, and the question is, will they be held deportable if they had past acts in association with a group of 5 or more? So my amendment tries to clarify that point and ensure that there's not this wide fishnet of deportation. And I ask the members to consider the amendments.
Thank you very much, and I appreciate you taking time with us. Ms. Jackson Lee, probably 2 weeks ago, I had an opportunity to watch National Geographic channel, which is one of my favorites, and I looked at an hour-long documentary on Bexar County, Texas, which is San Antonio, and the gangs that are being held, incarcerated in San Antonio, and the gangs in Harris County. And these gang members were very open to say, we're a gang. They're Hispanic gangs, notwithstanding MS-13 Colombian gangs. They are very dangerous people. They openly admitted, we intimidate anybody who gets in our way. We'll take anybody down in this jail. They're open in federal and state penitentiaries. They are gangs that are dangerous. They rule through intimidation, robbery, rape, poisoning, murder, beatings. I don't know how to describe all the things that I saw in that documentary, but they have decided that it is a way of life. And I will just tell you, I watched these the other night for a reason, and I don't know whether any member has had a chance to look at these, but our prisons and our jails are full of people who are dangerous, who would harm innocent people, disabled people, seniors, anybody that gets in their way. And I want to help and aid law enforcement in a way that would allow them, using existing law that has been tested in the courts, has tested by in California law and other people who have come into contact with them. And I believe it is vitally important that this nation look at criminal aliens before we go looking at maybe someone else who gets up and goes to school every day, someone who's aiming perhaps to go to Texas Southern or University of Texas or Colorado State University, people who play by the rules, but people who are in these neighborhoods where some of our most vulnerable children are and other people. And to refer to an 18-year-old or 19-year-old with a wide net of trying to gather people, this is intended right here as a bill to catch criminal aliens who are dangerous. The the Secretary of Homeland Security would have to come directly to Congress and tell us who these people are. That Secretary of Homeland Security, as it is the acting director now, she would have to come to Congress and stay up with us and report the gangs and report what's going on, and to actually take the advantage for, I think, real live people who are innocent, who get up and go to work, who take care of their children, who perhaps their children are bullied by these 18 and 19-year-old thugs, these gang members who openly consent to criminal behavior. That's who this is aimed at. It's not aimed at the Catholic Church or nuns or just a bunch of people smoking dope. This is aimed at criminal violators who are in our cities, who reside in our jails, who recruit and gather people to rob and rape and murder and pillage our cities. The Republican Party is responsible for this. I'm a Republican, and we are going to stand up, and we are going to give ICE and federal law enforcement an opportunity, a better tool, a tool that they will be able to take and say, I have a law that has been vetted in other states, I have a law, we're going to aim our prosecution, we're going to aim our resources at criminal aliens. This isn't aimed at people who are just walking down the street and going to church and trying to live by the laws. This is aimed at if you go about 15 miles from here over in Virginia, I can take you to the neighborhood. I've been over there where these thugs are mean. They are violent. They mark their territory. And I've seen them in Dallas, Texas. I've seen them across the country. That's what this legislation is. And it is intended at criminals. It's intended at criminals who would harm my family, who would harm families that I represent. And I just want you to know, we do appreciate you being here, but 18 and 19-year-olds calling that a wide net, that's exactly what we're going to do. We're going to get after 18 and 19-year-old thugs who do run in gangs of 5 people, who beat up people, who just take advantage. So that's right. I'm guilty as charged. This is what we're going to do.
Mr. Chairman, may I make a comment to your comment? First of all, certainly National Geographic is a worthy media source. I would like to think that criminal justice and justice is an American issue. I would like to also suggest to you that my comments did not diminish the violence of individuals who are...
Did not mean to suggest that. What I would say is 18 and 19-year-olds is not a wide net.
Let me, if I might say, diminish the dangers of MS-13. What I'm saying is what the bill may be aiming toward may not be what it accomplishes. And so it's difficult for us to write legislation that already has due process failings that wind up in the courts and not be what we want it to be. And I don't see any firewall that suggests that it could not be a younger person than that. I don't see any firewall with precise definitions, and I think one of the members said they wanted to meet the police officers that were not interested in operating under this bill.
In fact, one of our members did say that.
Yeah, but let me say this, 2005 is not 2017, and it might have been a better approach to hear from police officers from various jurisdictions on what would work better. What I've seen through here...
I think we did.
What I've seen here is that I have not seen legal definitions. I've not seen the firewall preventing discrimination against individuals that are just caught up in the wide net. And yes, you can be, whether you're 18 or 19,
Well, that's
17
what
or
a court
16.
of law. That's what a court of law would be used
I
for.
think we should not write bills that already have an Achilles heel to them. And I don't see the legal standards, and I guess the idea of acts in the past opposed to what you're doing now. If this person is rehabilitated with tattoos, is there some reprieve here? So I think that we have dealt with gangs. If anyone's known prisons, as you well know, there's been a whole myriad of transformational changes from MS-13, but there were gangs way back. There were white gangs, black gangs, there are Hispanic gangs, there are U.S. gangs, and now, of course, that MS-13 is violent. The issue is whether or not it opens itself up to discrimination and as well to not having the standards that are necessary, and that's my question.
Well, and I
That's what's on my
appreciate
minute.
that. I want to open this up to defeating criminal behavior of
And I don't-
gangs and people who wantonly go out and create dangerous circumstances for our children, our wives, our families, our people who get up and go by the rules. Dr. Burgess? Gentleman does not seek time. Mr. McGovern?
Yeah, thank you for being here. I was going to ask you, what the vote was on your amendments in committee, and I just remembered there was no hearing and no markup.
It wasn't, it was in
Right,
2005,
yeah, no.
12 years ago.
And I think we're going to urge, that there be an open rule, but the chairman of your committee has asked for a closed rule, and again, we all want to go after gangs, but we want to make sure that there aren't unintended consequences. And I always believe a bad process results in a bad product, and I think that's what's happening here today. But we'll do our part, but this process is rigged, and it looks like it's going to be a closed rule, so I apologize in advance for that, but thank you for being here.
If I may, Mr. McGovern, just simply say I echo wanting an open rule, and the only other point that I put on the record is that, to my knowledge, the Democrats that I've worked with all stand against violent criminal behavior, and so we stand with you, Chairman Sessions,
Yes, ma'am.
on the idea of protecting the American people. I don't think there's a divide amongst us, but I do think there's a divide in making sure that when we pass legislation, that it doesn't conspicuously have an open Achilles heel exposed. But I thank you very much. Thank you, Mr. McGovern.
Judge Hastings? Yes, ma'am. Did you get a chance to offer him happy birthday from last week?
Yes, I did.
Okay.
I was.
No, we haven't made that yet, Judge.
We were here on Hurricane Harvey, and I wished him
Is there
happy
any
birthday.
member that would seek time? Okay. Look,
Okay.
Ms. Jackson Lee, thank you for
Thank
coming
you
by
very
here.
much, Chairman.
And let me tell you this. I do know you represent people, lots of them, who want and need to be safe in their home in Houston, Texas. And I do the same, and I think every member does up here. And I appreciate you taking the time to be here today. If you'll please make sure we've got two awesome stenographers here tonight. If you'll please make sure whatever you brought in writing be available to them. Thank you very much. Is there any other member that seek time for the committee? All right, this closes the hearing portion of H.R. 3697, Criminal Alien Gang Member Removal Act. This closes that hearing, and the chair will now be in receipt of a motion from the gentleman from Louisville, Texas, Dr. Michael Burgess.
Mr. Chairman, I move the committee grant H.R. 3697, the Criminal Alien Gang Removal Act, a closed rule. The rule provides for 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that the amendment printed in the Rules Committee report shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides that on any legislative day during the period from September 15, 2017 through September 22, 2017, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and a time to be announced by the chair in declaring the adjournment. Finally, Section 3 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 2.
Thank the gentleman from Louisville, Texas. I will defer to myself for 1 minute. This is one rule, one bill, contains within it, as we know, the floor management tools responsible for the district work period, which would be next week, and allowances that need to be made there. Is there amendment or discussion?
Yes, Mr. Chairman, I
Gentleman's
have an
recognized.
amendment to the rule.
Yes, ma'am.
I move the committee grant H.R. 3697 an open rule so that all members will have the opportunity to offer amendments to the bill on the floor. This is just another closed rule, and since I know we're in a hurry to reauthorize the FAA and do a lot of other work, child health, but as long as we're going to take a day on this, I think we might as well be open to give people an opportunity to really talk about something that I'm sure they have many thoughts on this subject.
Yes, ma'am.
We don't want to shut them out.
Matter of fact, we had a couple of people that did have thoughts.
Right.
They showed up here,
Right.
here tonight. Further discussion. Vote now be on slaughter amendment. Those in favor signify by saying aye. Those opposed, no. Those have it, noes have it. Gentlewoman asks for roll call vote. Clerk will poll the committee.
Mr. Cole, Mr. Woodall, Mr. Burgess. Mr. Burgess, no. Mr. Collins. Mr. Collins, no. Mr. Byrne. Mr. Byrne, no. Mr. Newhouse. Mr. Newhouse, no. Mr. Buck. Mr. Buck, no. Ms. Cheney. Ms. Cheney, no. Ms. Slaughter. Ms. Slaughter, aye. Mr. McGovern. Mr. McGovern, aye. Mr. Hastings. Mr. Hastings, aye. Mr. Polis. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 7 nays.
Amendment's not agreed to, not agreed to. For amendment or discussion, seeing none, the vote will now be on the motion from the gentleman from Louisville, Texas, Dr. Michael Burgess. Those in favor signify by saying aye. Those opposed, no. The ayes have it, the ayes have it. Gentlewoman asked for a roll call vote. Clerk will poll the committee.
Mr. Cole, Mr. Woodall, Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse. Mr. Newhouse, aye. Mr. Buck. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter. Ms. Slaughter, no. Mr. McGovern. Mr. McGovern, no. Mr. Hastings. Mr. Hastings, no. Mr. Polis, Mr. Chairman. Mr. Chairman, aye. 7 yeas, 3 nays.
You handling this? And Judge Hastings will be handling this. I need to announce that evidently I've stated something wrong at some point in my life, and that Dan Newhouse is from Sunnyside, Washington. And I don't know when I got it wrong. Did I say something other than Washington? Well, not you. No, I've got Miss Booth over here, your spy who is our clerk, has evidently have done something wrong. So, Miss Booth, I apologize for getting your man's stuff wrong. Okay, accordingly, we do not expect to meet again this week. Thank you very much. The committee has finished its work for the week.